I'm just gonna give a brief delay as people come in and take their virtual seats. Just watching the numbers tick up here. Okay, great. Well, we're going to go ahead and get started. Thank you so much for joining us this evening. My name is Amanda Herbert, and I am the Campus Outreach and Events Manager for National Review Institute. For those of you who are unfamiliar, I'm just going to say a few words about our on-campus program and partnership events, such as this one. Our founder, William F. Buckley Jr., began his career as a public intellectual by writing God and Man at Yale. This was a scathing critique of his alma mater and its growing bias towards secular collectivism. Bill Buckley understood how vitally important young people are to the future of our country, and he frequently spoke on college campuses. He would make his rounds. He would visit over 50 a year, in addition to all of his hard work on National Review, in addition to everything else he was doing, simply to promote the principles of classical liberalism and limited government. And it was Buckley's unyielding dedication to these principles that united the freedom movement and launched conservatism back into the political mainstream. It's in this spirit that National Review Institute brings the National Review mission to college campuses, and during this year, virtually to college campuses, where it provides opportunities for college students to learn about the principles and ideas of a free society and empowers them to stand athwart history. We are so grateful to be able to do partnership events with allied organizations such as Independent Women's Forum this evening. Social media and conversations and ideas rooted in Buckley's own powerful campus legacy to college students. If you're interested in partnering with us, if we can bring speakers, our NR talent, our NRI fellows to your campus virtually or hopefully soon in person, then please reach out to me. I'll put my contact information in the chat box. And also for all current students who are on the call with a valid .edu email address, I can get you a complimentary subscription to National Review Online. So if that's of interest to you, let me know. And with that, I'm going to turn it over to Ashley to say a few words.
Thank you so much, Amanda. My name is Ashley McClay, and I'm with Independent Women's Forum. For those of you who don't know, Independent Women's Forum, or IWF, is an organization dedicated to building support for free markets, limited government, and individual responsibility. We seek to combat the too common presumption that women want and benefit from big government. IWF knows that all issues are women's issues, and we produce informative materials and about timely policy issues and are very active in the media. We feature inspirational women leaders through our Champion Women series, and we offer listeners a fresh perspective on numerous topics through the She Thinks podcast. You can find us out more at iwf.org. And tonight we will be discussing a very timely policy issue. I would like to welcome our panelists. Alexandra DeSanctis is a staff writer for National Review and a visiting fellow at the Ethics and Public Policy Center. She was previously a William F. Buckley Fellow in Political Journalism with the National Review Institute and is a graduate of the University of Notre Dame. Inez Stepman is a senior policy analyst at the Independent Women's Forum. She's the author of numerous policy papers, and her thoughts on policy have been published in numerous outlets, such as the Washington Examiner, The Hill, and others. She frequently testifies as an expert in state legislatures across the country, and she's a proud first-generation American. She holds a BA in philosophy from the University of California, San Diego, and a JD from the University of Virginia School of Law. Lastly, we have originally from Glasgow, Scotland, we have Madeleine Kearns, and she's a staff writer at National Review. She's written for the Wall Street Journal, the Daily Telegraph, the Daily Mail, Standpoint Magazine, Unheard, The Scotsman, the Catholic Herald, Verily, and Heterodox Academy. She also writes and performs music. With that, I will turn it over to our panelists. Welcome. Thank you all.
Thank you guys so much. Thank you, Ashley. All right, well, we can go ahead and just kick this discussion off. So if you guys want to talk a little bit about what were the original intentions? What was it designed to do when it was brought into policy in 1972? Inez, you want to kick us off?
Sure. So it was an amendment, right, to the Civil Rights Act that was passed in 1964, of which Title VII actually already talks about sex discrimination. So there are two different places within the same law that talk about sex discrimination. But Title IX was really passed to deal with pervasive harassment, sexual discrimination within educational institutions, and basically leveled the threat from the feds that if this kind of rampant sex discrimination rising to a level where a woman would be unable to really take advantage of the educational opportunities to which she is owed, if a school allowed that kind of rampant sexual discrimination, then it would be ineligible for federal funds. So that's extremely important for universities. So Title IX is not only applicable to universities, but it's extremely important for universities because of the way that our education system, our higher education system works, right? So virtually all schools, with a couple exceptions like Hillsdale College, are completely dependent on federally backed student loans, which means all of them are recipients in some way of federal money. And so that's why the original intent of this actually was very broad, but it's, as we'll see, and I'm sure we'll get into, it has taken on certainly a life of its own. It's had tendrils going out on all kinds of issues, such as, for example, the definition of sex and whether universities will be allowed to have sex segregated sports teams or locker rooms, now that we are dealing with the question of how to categorize people who are biologically one sex and claim membership in the other sex, and as well with the issues of harassment and sexual assault and how those issues are dealt with on college campuses, how accusations are dealt with, what due process rights the accused is going to have if the accused is going to face very, very high consequences for whatever's decided in these tribunals. So I'm sure we'll dig into more of those issues. But Title IX has really spun out much further than I think its original narrow purpose was to ensure that women, institutions that were accepting federal dollars were giving women a fair opportunity to go ahead and engage in the education to which they were owed.
I think that's right. And what's interesting as well is that the design and the purpose and the intention of it was really to remove barriers that were getting in the way of women's opportunities, women's ability to compete in sports. That was we were talking about this before. That was an initial concern. And then it morphed into a concern with sexual harassment. And this actually, the relationship between Title VII, which as Inez says was about employment, and Title IX is interesting in a number of ways. There is a parallel going on in the sense that in the 1980s, the Title VII was the first thing to introduce this concept that sexual harassment in the workplace is a form of discrimination. Of course, there's all sorts of behaviors that would be criminal. So harassment, assault, rape, these are all criminal behaviors. But the reason that they related to this discrimination law was how they could also deny opportunities, fair treatment in the workplace, first through Title VII, and then in 1999 with Davis versus Monroe, it was taken into the campus setting. But as Inez says as well, it's important to highlight that at that point, it was supposed to be reserved for behaviours which were severe, pervasive, and objectively offensive, whatever that may mean. And as such, behaviours that directly prohibited or denied women equal opportunity as they were supposed to have. This obviously has spun out of control, become a lot broader. So we're now talking about things like a hostile environment, what constitutes a hostile environment, it becomes very subjective very quickly.
Well, and Maddie, I think that's a good point, and leads us sort of into the second point of how Title IX sort of collides with the First Amendment and our First Amendment rights as citizens, and sort of takes away some of those if you're asking what's appropriate and what's not. Can you guys speak to that?
Sure. I don't know that I'm the first expert on this particular question, but I would say I think once we're dealing with a situation where a policy that was intended in the first place to protect women from specific kind of concrete types of discrimination, suddenly this is being used to, construct these essentially kangaroo courts on campuses where men can be accused and not really have their due process rights when they're trying to figure out what's happening in some of these harassment or assault situations, sexual misconduct situations, or we're applying it to, now these fights over whether or not biological males can participate in women's sports. We've taken this out of kind of the realm of concrete discrimination against someone because of their sex. Suddenly people can allege all sorts of harms that were done to them that don't have anything to do with them being a woman or a man necessarily. And that means, well, so-and-so may have said something that was harmful to me or psychologically bad, or coupled with this kind of safe space mentality on college campuses. When you put those two together and you kind of change harm from something very concrete done specifically because of your sex to this kind of nebulous self-defined concept of having been harmed, you have a really dangerous situation where a lot of people's speech is being silenced effectively as having been harmful to someone else on campus.
Yeah, and just to follow up on that, actually to something that both Madeleine and Alexandra said, we once had this standard of harassment. So there's two separate issues here. One is sexual assault and accusations of sexual assault or sexual misconduct. The other is harassment. Both definitions have gotten just broadened unbelievably over the years, in my opinion, to try to jam back some kind of guardrails on the relations between men and women, but in a totally inappropriate and legalistic forum, right? But specifically to the concept of harassment, one of the problems we've seen with the enforcement of Title IX on campus under the Obama administration, and something that I think we can expect to see under a Biden administration, to come back under a Biden administration, is this broadening of the concept of objectively offensive that Madeleine referred to in the Monroe versus Davis standard, right? That standard, it sounds like, oh, how are we going to define objectively offensive? But actually the law does have a standard for that. It's a reasonable person standard, right? A reasonable person. So it's not a subjective, it's actually within the law. It's something that either is determined by a jury or has some reference to a sort of stand-in reasonable person, but not the subjective feelings of the person, because we previously understood that what one person finds offensive, the other person finds attractive or interesting to listen to, right? So that kind of subjective standard isn't workable legally. But unfortunately, that's the kind of standard that we see campuses implementing, and especially under the Obama administration, and it really eats into protected speech and the First Amendment, right? So we had cases where we had speech that was, for example, general commentary about gender roles or the appropriate relations between men and women as social or political commentary or as cultural commentary being interpreted as a Title IX violation, right? As something that could be written up. We had professors face consequences, for using inappropriate language in the classroom, not towards a particular student, but just language that some particular student found offensive within that context. And then finally, of course, after the Kavanaugh hearings, we had students filing Title IX cases against Kavanaugh in the classroom as a teacher or as a professor because of some of the things that he said, right? These are, that's a very dangerous broadening of the concept of harassment, which previously had some objective parameters on it. It was required to be pervasive and repetitive. It wasn't just a stray remark or a stray joke that somebody found offensive. And we're seeing it eat into actual political speech as well. And for that reason, and I'm sure that the sexual assault category that we'll talk about at length at some point here. That's part of the reason that Secretary Betsy DeVos actually promulgated new rules to first withdrew the Obama administration's guidance and then promulgated new rules, both to try to secure some basis of due process for people who are accused of sexual misconduct, but also this important harassment piece, right? To make sure that, in protecting their students from quote unquote harassment, schools are not actually infringing upon the First Amendment rights of their other students or of their employees.
Wow. So, so you touched on a little bit on what Obama did while he was in office and sort of the cons of that. Are there any pros to any of the policies that Title IX policies under the Obama administration?
I don't think there's there's a long list of pros with the Obama administration. I do think that we briefly discussed before this call. We briefly discussed sports, and I do think that there was an interesting debate happening in the 1970s, which is not so relevant now. But it was about funding and whether it was fair as the law was requiring colleges to do, which is set aside funding for women and make sure there's equal investment in male and female sports. This did actually have an effect, I think. It did open up sports for women. Whether it was appropriate or not, or the best way of doing that is another debate. What's actually interesting, though, is we kind of seem to have, by a very unlikely route, we have returned to the issue of sports. By a very, very, very unlikely route, in that we are now talking not about how we can make sports more fair for women in giving them more funding. We are now arguing about whether a biological male should be allowed to enter into women's sports teams. This is not a pro, in my opinion, of the Obama era, but this was a major con of what he did. Inez talked about the sort of interventions that the Trump administration did with regards to sexual harassment. They also did a number with regards to gender identity, including clearing up the mess of Obama's Dear Colleague letter of 2016, which basically advised colleges to treat members of the male sex as female if they identified as such for the purposes of spaces in sports teams. This caused a massive mess because what you had was a patchwork situation where some states were suing because their college hadn't lived up to this, whereas others were suing for the opposite reason. And Betsy DeVos also came clear on this and said, look, if Congress wants to redefine sex, Congress has to do that. It's not up to us to do that. The problem is that they went via the initially they were going to sue with the Administrative Procedures Act. But of course, this became moot when the Trump administration came in and said, no, we're getting rid of that guidance. So we're basically at where we were 4 years ago, which is that this new Biden-Harris administration is going to come in, very likely send out that Dear Colleague, a new but identical Dear Colleague letter. And we're going to have this litigation, which takes a while to resolve. Meanwhile, mass confusion and patchwork situation like throughout the states. So yeah, I think that the Obama era, Obama Biden and now Biden Harris era is one of the legacy is one of confusion more than anything else.
And I think I'm glad you raised Congress, Maddie, because I think a huge part of the problem that we're dealing with here is because something that properly started out in Congress, and I think when at the time that this was passed, it was needed in some ways. It might not have been exactly the right solution for what was being dealt with. In my opinion, it's maybe a little bit too top down of a solution for something as huge as sexual discrimination. But it started out properly in Congress, and now suddenly this entire fight is playing out in the executive branch, and then in the administration, and in all these agencies, and the Department of Education in particular, that are these bureaucrats that are trying to police what's going on college campuses. And every 4 years or every 8 years, we have this turnover. If the political party changes, this turnover in the entire approach to whether or not certain things are sex discrimination or not, whether they fall under Title IX. Sex discrimination is not it does not have to do with how campuses handle sexual misconduct allegations. It should not have to do with whether or not biological men can be on women's sport. None of this should properly fall under this one, congressional statute that was passed. Congress has to deal with each of these, if it wants to, has to deal with each of these problems as they arise in a new and clear way, rather than having one administration after another come in and just kind of make up whatever it wants, add it on, tack it on under Title IX to try and create this sort of umbrella policy to make college campuses do what they want it to be doing according to their sort of political vision. I think it's really kind of problematic in a constitutional sense, I guess, that this is the landscape we're dealing with.
I couldn't agree more with Alexandra about the administrative state issue. These dear colleague letters have massive separation of powers and constitutional problems as a whole, but that's sort of the regime we live under now for administrations of each political party. But just to show how far we've gotten from the 1972 legislation that we're talking about, the only mention of sports teams and sort of integration, sex integration on campuses came from the sponsor in the Senate of the amendments that became Title IX. And he said, we are not requiring that intercollegiate football be desegregated, nor that the men's locker room be desegregated. By that, I mean desegregated by sex, right? So just to see how far we've gotten from what people, nobody in 1972 would have ever, had the notion that was actually the interpretation that was sent out in that Dear Colleague letter that Madeleine referenced from the Obama administration, which is that discrimination on the basis of sex includes discrimination on the basis of sexual identity, right? So that's the interpretation that the Obama administration sent out. That's the interpretation that was then reversed, but can be reinstituted in the next administration with literally just a letter. They call them Dear Colleague letters because they start out Dear Colleague, and then there's 12 pages of how the administration is going to enforce the law. That allows them to avoid not just going through Congress, as Alexandra said, but even going through the APA rulemaking, the Administrative Procedure Act rulemaking that often can take years to get through, that has some safeguards, has some room for input from interested parties and from the public and so on. So we really can have this whiplash regimes where every time a new administration comes in, with the stroke of a pen, they can change very substantially the interpretation, even if it has absolutely nothing to do with the way the original law was conceived. But there is a second argument the argument the Obama administration was using for the Dear Colleague letters was discrimination on the basis of sex also includes discrimination on the basis of sexual identity, right? So that interpretation can come back. That's sort of one avenue in which I think we will see Title IX used to make sure that biological males have access to female spaces on campus. The second possible interpretation comes from Title VII after the Bostock decision, which is a little bit of a different legal way of thinking, and I think could produce, even though it produces at the end of the day sort of the same consequences, it's a line of thinking that, as we saw in Bostock, can get some conservative jurists to have to come on board because it's very much sort of a textualist letter of the law as passed, which is that if somebody, so it doesn't bring in gender identity at all. It doesn't admit or deal at all with the question of whether a biological man who claims female identity is a woman, which is kind of the assumption of the Obama Dear Colleague letter. It doesn't deal with that question at all. What it says is, if you would allow a similarly situated woman access, right, to a sports team, or in the private sector in the employment context, right, if you would allow a female employee to wear a skirt suit, then you have to allow a male employee to wear a skirt suit because if he were a woman, he could wear a skirt suit. And so that's a discrimination based on sex, right? That is in some ways a much broader ruling, right? When we are talking about gender identity, we're talking about a very small percentage of people who have one biological physical sex and then claim membership in the other. And that's not to downplay the consequences that that can have, and already has in a lot of sports contexts, for example, and in context of locker rooms and public bathrooms and public school bathrooms and all of that. So I'm not downplaying the issue, but the reasoning of Bostock that could be applied to Title IX is potentially broader, which is anytime you exclude somebody on the basis of sex, that runs afoul of civil rights law. Anytime you admit a woman somewhere and not a man, and not just somebody who identifies as a woman, any man, it doesn't matter. You know, the 16-year-old boy who just wants to be in the women's locker room because he would like to be in the women's locker room, doesn't claim female identity, you know, is not dressed as a woman, nothing. If he's being kept out on the basis of his sex, that could be considered under the Bostock decision, and courts are going to take a very long time to sort of separate out and put meat on the bones of the doctrine that Bostock put forward. And I imagine that a lot of that shaking out through the court system is going to then affect the interpretation of Title IX, which has a lot of the same language and a lot of times has some has like sort of parallel interpretations under the law. So I think the issue is sort of larger than that. It's not just about what to do with a small percentage of people who are biologically one sex and claim membership in the other. It's about the notion that somehow it offends equality, or it is a discrimination on the basis of sex to ever treat men and women differently. And that's a much broader, in my view, much more dangerous concept.
I would agree with like almost everything you're saying, except for the fact that my understanding of Bostock was that they spelled out that in this particular case, as with other cases, the person was discriminated on the basis of sex because gender identity, which they reference, necessarily entails sex. And it's really a sophist argument, I think. I mean, I know it was defended on textualist grounds, but I think that it comes back to the argument that the ACLU lawyer made during the oral arguments, where he said that but for the fact that Stevens, the plaintiff, was born a man, he would have been able to enter the women's changing room or dress as a woman. And then your conclusion is absolutely correct. That my concern as well is that we have this very, very complicated Supreme Court decision, which could be read a number of different ways and is already causing trickle-down confusion in various ways. But at the same time, we have the Equality Act, which has just passed the House. And of course, the Equality Act would seek to amend the 1964 Civil Rights Act so that sex includes gender identity, which was the interpretation that we'd all feared for Bostock, which the court didn't do. They did the thing that you've described. But now we have this looming threat of the Equality Act, which Biden-Harris administration has promised they're going to pass within 100 days. They're going to get done within 100 days. And so then we're going to have this situation where we have the federal government mandating that everybody who's receiving financial aid treats sex as if it included gender identity. But then you're going to have individual states saying, no, we're not willing to do that. And then it's going to end up probably in the Supreme Court, who have this very, very complicated interpretation of it. So I don't know. I think the whole thing is quite a mess, to be honest.
No, I agree. And we're not going to know. There's going to be a lot of consequences that play out on the ground long before these issues are resolved in the Supreme Court or anywhere else in the court system. So definitely would second your fear of the Equality Act, but also the ERA, I think, is also a sleeper issue in this regard. So we had the House last year dissolving the deadline. There's all kinds of, I'm not going to get into all kinds of the like debates over the procedure as to whether this is a valid amendment or whether they have to go back and try to pass it in one continuous go rather than counting ratifications from the 1970s alongside 2016, 17, and 18. But nevertheless, I think we keep coming back to this question, right? And of whether or not it is a discrimination based on sex to have separations between men and women, or to treat men and women differently in any way. And just to generalize away from the legal context for a minute, I do think this is the primary problem, not just with Title IX, not just with Title VII, but the entire way that we think about these issues. We tend to think, or at least one part of the political spectrum seems to think, that in order for men and women to have some kind of equality, they have to be treated the same. And I think that is an interpretation that very much comes out of the context of race in this country, both legally and in the public conversation. But I don't think that it's actually applicable to sex, right? Unless you're unless you're Richard Spencer, or like one of the actual, sort of racist crazies on Twitter. We don't believe that there are significant biological differences between the races that would impact, for example, how a Black person or a white person would be treated under the law. And for that reason, we are extremely suspicious, right? There's a very high bar in the law against the government treating races differently. So I'll give you just one particular example. There are a lot of racial gangs in prison, right? But that even the violence that results from that is not considered a good enough reason for the government then to separate prisoners on the basis of race, because we think this is such a terrible thing that we have had, a history of in this country, that it's just inappropriate, even if there are very large consequences to it. Now, sex is not like that. Men and women are biologically different. And sometimes those biological differences are the difference between, safety and serious bodily harm for women. So for example, we do separate men and women in prisons because women are particularly physically vulnerable when they are housed with men. And again, we're confronting all of these same issues with regard to the transgender debate or transgender accommodation debate, but there you're talking about a small percentage of people, whereas the ERA and potentially the Bostock line of reasoning and some other sort of elements of this debate, all of which center around the same issue. Is it ever appropriate to treat men and women differently? Is it ever appropriate for the law to recognize those very real biological distinctions between men and women that may not, have an impact when we're talking about, who can be a chemist or an astronaut, right? Obviously, women can do those things as well as men, but they do have an impact when you're talking about battered women's shelters. They do have an impact when you're talking about, prisons, when you're talking about men's and women's sports teams in universities. And to ignore those biological differences, as we are being asked to do, or to pretend that they don't exist, is going to be devastating for women in this country.
Yeah, and actually that is the very point that Ruth Bader Ginsburg actually raised in the oral arguments for Harris versus the EEOC, which was the case within the case in the Bostock decision. You're absolutely right. I mean, it's and with the analogy you gave is a very good one, because you can clearly see why it is that we approach it differently, and it's from like ancient wisdom. We just know that like women are more vulnerable to risk from men than men are from risk from women.
But I'm glad that the whole sort of where this collides with feminism came up, because I find it so interesting how the kind of advance of progressivism into this new dogma of, the kind of Equality Act logic, or the, biological men must be permitted on women's sports teams if they identify as women, how that kind of branch or wing of progressivism collides with the decades-old feminist quest, which is where the anti-sex discrimination provision, where we got Title IX, where we got a lot of things I agree with, but how, you can't both believe that, there's something good about being a woman, there's something unique about being a woman, that women can contribute something, that women are, unique and important and special, and also men can claim to be women, or men are the same as women. Those things don't go together. And so you have people who on one hand claim to be the champions of women's rights, and girls and women all over the world are the same people who are saying men and women are exactly the same, and men can be women if they say that they are, and men can be in women's spaces, women's privacy doesn't matter, girls' rights don't matter, when it kind of conflicts with this other progressive dogma that we now have to believe in. I think we're seeing that sort of work out, unfortunately, not on a small scale where everyone can weigh in and sort of have this fight as a culture, as even a political matter. We're seeing it play out in these kind of heavy-handed, sort of like I was saying before, like the administrative state and in the courts, where we have basically no access to the people who are creating policy for us on these really contentious issues where we've essentially lost sight of what it means to be human, what it means to be a man, what it means to be a woman. Like when it comes to sexual assault, there's something very fundamentally wrong with what's going on college campuses. And that's not going to be solved by these kangaroo courts where men are kind of hauled in and given no chance to defend themselves over things that most of the time happened in a very messy, unfortunate way, but probably were not criminal behavior. And we're trying to sort that out in a courtroom kind of setting. Like none of that is really the proper forum for these sorts of debates, I don't think.
So that's a really good transition, and I don't want to waste the transition to the issue of sexual assault, which I absolutely think we need to address, because it is the foremost issue, I think, under Title IX now, or especially will be with the Obama administration, or this Obama administration, the second one, Biden administration coming into office. But I actually would like to sort of maybe controversially push back a little bit against the idea. So I know that there are the TERFs, right, the radical feminists who argue exactly what you just did, right, Alexandra? Obviously, you're not a radical feminist, but you are making a similar argument, right, that there is this contradiction between sort of old school feminism and the new rise of sort of gender identity or the irrelevancy of sex, right? I think they're contradictory only on the surface, because I think one is sort of the inevitable consequence of the other. Because feminists from the beginning, so when I say beginning, I mean like the Simone de Beauvoir and Betty Friedan and the initial waves of what we might call, I guess, second wave feminism in America, has always been hostile to the idea that sex is an important factor that shapes our identities and our lives, right? So the common feminist formulation that's in the dictionary is that men and women should be cultural, sociological, and economic equals, I believe. And while I absolutely believe that everybody is entitled to the protection of the law, and don't, obviously don't agree with legal barriers to female advancement, the underlying idea that men and women should be the same in our homes, in our culture, in our society, as economic actors, that equality in all of those things is a positive or something to be striving for. I think we end up, if we say that sex is irrelevant to your career choices, to the way you're going to live your life, to the way you interact with the opposite sex, to all of the ways in which we interact with each other, it then begs the question, well, what is relevant about sex, right? And so the position of I think those feminists is essentially sex is only relevant in this very, very narrow, like physical, biological way. And I'm not sure that that's obviously I agree that the biological differences are important, but those biological differences aren't skin deep, right? They're not just a matter of this kind of genitals and that kind of genitals and a little more upper body strength on the part of men. Women and men are deeply neurologically different. They're psychologically different. We should expect them to make different choices on aggregate. Now, that doesn't mean we need to, prevent women who want to make choices that are more masculine from doing so by law. Of course, that's not the case. But I do see a connection, like a philosophical thread that runs through there that says sex is not definable, or to the extent that it's not definable, it's not important. It shouldn't really impact your life. And I actually think I'm considerably older than the two of you. I think I'm the oldest person. I'm like the middle millennial. But I think that's really been very damaging for young women from my generation and from you guys coming up behind me. I think it has set up a standard where basically what men have done for centuries is the standard. And if women choose to make different choices on the aggregate, we're always on the defense trying to say that's not discrimination, it's free choice. We should expect different outcomes between men and women on aggregate, right? Any individual could be an exception to this, but on aggregate, we should expect those different outcomes. We should expect there to be men's and women's teams because there are obvious differences, but we should also expect that men and women make different career choices. that women might prefer more flexibility over, you know, a high-powered salary, that they might expect to spend more time with their family or even with their friends, right? That they're more interpersonal, that they choose jobs where they interact with people more rather than preferring jobs where they're in a cubicle interacting only with a computer. Like, these should all be things that are very common sense and that we should expect and embrace these differences between men and women. But yeah, I don't want to screw up the transition because we really do have to talk about sexual assault, but it's sort of a deeper objection I have, not just with the left feminism, but also sometimes with my own team of conservatives. Sometimes it seems to me that we are always on the defense with this, and we're always saying, well, it's individual opportunity that matters, which of course is true. But if you don't set up the expectation that the way in which men and women take advantage of the great freedoms and opportunities that we all have in this country are going to be different, then you're always going to be chasing that discrimination dragon, I feel like.
Could I just say a point which I think aids the transition a little more, which is actually also related to a point Alexandra made about the cultural context and how things that tensions and conflicts in a cultural context are being worked out through litigation, and that's not ideal for anyone. And it was reading Deborah Soul's new book. So Deborah Soul, the sexologist, and she made a really, really interesting point, which few people dare to make now, about, on average, when you poll women on the question of casual sex, how they feel about it. And actually, she makes the case that there's deep-rooted evolutionary reasons why women are less likely to feel happy about that decision afterwards. And I think this is something that, because we'd rather not address that in the culture, we'd rather say, you know what, the cat's out the bag, people are going to do what they want. We end up living this contradiction where everything is permitted, but nothing is forgiven. And I would argue that everything being permitted is really, really bad for women in the sense that they're permitting it. And nothing being forgiven is really, really bad for men in the sense that they're not forgiving mistakes. There's a question, and this is impossible to generalize about because you have to look at things on case by case, and there's the individual circumstances of whatever the accusation is. Of course, that's true. But we do also know that the complexity of looking back on a situation and regretting it, when you combine it with this very swift decision to solve things through litigation, is a really, really unfortunate, potentially toxic combination. And because we know that sexual encounters and the relationship between men and women is messy and complicated, and it's not normally aided through massive top-down big government intervention. So now we can talk about sexual assault.
Yeah, I guess we'll kick it off. So within I'll just lay out what I expect from the Biden administration. I'm very curious to see if you two expect something similar. The situation that we have right now is unlike some of these other issues that we've been talking about, like transgender accommodation. There was just that guidance, and that guidance was repealed, but then can be placed back under a potential Biden administration. However, in the case of sexual assault and due process, there was an actual rulemaking through the APA, a process that took over 2 years to get going and to finalize. Nevertheless, there is now a promulgated regulation that provides certain elements of due process to anyone accused of sexual misconduct on campus. So, for example, the standard for the non-legal people, just the standard was dropped to basically more likely than not, right? So if 51% chance, the accused did it, then he's guilty. It was raised to a preponderance of the evidence standard, which is, something around like 75%. Like, it's really likely this accused actually did what he's being accused of. That's still lower than a criminal court, right, where it's beyond a reasonable doubt, but it's higher. So the guidance said that only that they can use any standard they want, but what they can't do is because what universities were splitting the baby, and they were saying, well, with regard to academic violations like cheating or plagiarism, we're going to use a preponderance of the evidence standard, or for example, professorial misconduct, like professional misconduct. So they wanted in all other contexts to keep a higher standard, but for this specific issue to drop it. And so what the new rules say is, no, you can't do that. You got to pick one standard. You can't carve out sexual misconduct as something totally separate and drop the standard for it. It also provided really important guarantees, including access to counsel. It heavily discourages and forbids the single investigatory model, which is just makes a mockery of any concept of sort of Anglo-American jurisprudence and due process when you have a single person from the Title IX office taking statements from both parties and investigating and then rendering a verdict. So, and also provides the ability through a third party for the accused to cross-examine. And there was a lot of misunderstanding about this piece. People imagine that they have to be in the same room or you have to be cross-examined by the man that you're accusing of sexual assault. That's not the case. They could be in different rooms. They can never see each other. It could be through a third party. Nevertheless, it's important to ask somebody who's coming forward with a story about something like this, questions that you saw the lawyer that Republicans during the Kavanaugh hearings asked, right? So the questions like, okay, what night did this happen? Did you talk to anybody about it afterward? Can we corroborate where you were, right? These kinds of questions are extremely important to get to the heart of the truth of what happened. And so all of those due process rights are now protected in this regulation. I expect the Biden administration to find a way to just tell schools that they won't be enforcing those regulations. However, that doesn't mean that students can't sue under them. So I don't know how they're going to fully shift these regs out of their purview. And when you add these regulations that'll take several years to undo for a Biden administration, to the fact that students have been winning already on due process grounds in federal court. There's been over 90 cases that have been resolved in favor of accused students walking back punishments that schools have meted out on the basis of as Alexandra so eloquently put it, kangaroo court, where no basic due process for the accused was respected. So I think that's kind of where we are, and that's kind of what I expect. But I don't know what you guys think. Do you think that universities are going to be worried about the lawsuits under the new regs, or do you think they're just going to full steam ahead back to the single investigatory model? Like, what do you think is going to happen?
I think there's an interesting, if not perfect, comparison here with the way in which the Trump administration tried to say that they weren't going to uphold elements of Obamacare, and the DOJ said, oh, we're not going to bother with that. And then it was taken to court and they lost that fight ultimately. And so I kind of wonder if it will play out similarly in this situation. I mean, I do think that it would take a long time for them to undo what they're doing. Obviously, the difficulty is, as we've already discussed with the Dear Colleague letter, is the ambiguity that causes for individual schools. You've also found, since these rules came into effect in August, you've also found that certain schools have said, okay, well, we're going to have two separate things. We're going to have Title IX allegations, and we're going to have our own allegation thing, which means they can kind of just ignore that, and if they want to have a lower standard of evidence for whatever reason, they'll just do their own thing anyway. And obviously, if they're a private school, I assume that's their prerogative. So I think the new rules are a good thing, and it will be a challenge for a Biden-Harris administration to negate them, but I don't think that will stop them trying necessarily.
Yeah, I'm glad that you gave those answers, because they made me a little bit more optimistic. I would have thought, and kind of still do think, that this is a priority for a Biden-Harris administration to really push to get this undone somehow. And I think whether that's via Dear Colleague letter, perhaps, or just making this one of the top priorities of undoing the previous administration's rules, because I think there's just you sort of raised this point, Inez, about the Kavanaugh hearing, and I think that's the perfect framework through which to understand what goes on campuses and why the left cares so much about getting rid of sort of the DeVos framework, or why they would prioritize getting rid of it. They don't actually care about getting to the truth. It's not about finding out what happened. It's about leveling the playing field or evening the score. The sort of rhetoric we heard from a lot of people after all those accusations came out against Kavanaugh, and basically none of them ended up being corroborated, at least the standard one would require, and several of them were just obviously nonsense. But they were entertained by people under this sort of rationale that, well, women have actually been assaulted for so long and they haven't gotten justice. And so even if this guy didn't do it, too bad, men have done it. And so women need justice. And that's what happens on these campuses. It doesn't matter if Joe Smith actually did the thing. All sorts of Joe Smiths have done horrible things to women. And so we can just have this lower standard, and he can be kind of the scapegoat for the fact that women have been harmed for so long by men, which of course is true. Women have been harmed by men, but we don't solve that problem by pretending that Joe Smith shouldn't actually get a fair case in whatever accusation was leveled against him. But I think there's just kind of this psychology on the left, and a growing psychology, which we saw with Brett Kavanaugh in particular, that real feminism means just getting the man no matter what, because women need help and women have been harmed, and we have to kind of sort of make up for all the harms that have been done without justice by getting this sort of twisted form of justice against whatever man we can get our hands on.
Well, we only have a few minutes left, so we can sort of wrap up with Title IX doesn't fix the problems that it purports to. What, if anything, would?
I mean, I think this goes back to what all three of us have been saying in different ways, and I think in helpfully different ways. You can't fix problems of nature with a legalistic system that is wholly incompatible with the ambiguity and complications of relationships. It is a wholly blunt tool for that object. And I think it comes back to, again, not being able to recognize that men and women are different, being afraid to say that women on the whole might be more hurt by a casual hookup culture than men, that they might be looking for ways to describe those feelings of pain and rejection in the context of consent, right? It almost seems to me that we are repackaging bad sexual experiences under the banner of consent because our culture leaves no other way for us to talk about bad sexual experiences other than consent, because the cultural line and the line that I think at least my generation, your generation has been taught, but I think going back to the 70s has been, women can have sex like men, women can have casual sex like men. It's going to be great, it's going to be fun. And when it turned out not to be the case, it must be because we didn't really consent, right? It couldn't just be that you can have consensual, terrible sex with really bad emotional consequences. That would require questioning the premise. And so what we see instead is that we see these kinds of negative experiences repackaged in the only language that the culture finds acceptable, which is, well, we must have really not consented to this kind of sexual experience if it turned out to be bad. And frankly, this is an endless process of trying to legalese this up. People joked about the Chappelle sketch, right? About the, was it Chappelle? I think like a long time, like years, decades ago, or had the contract, the consent contract for sex. We now have consent apps, right? But those things don't actually even get to the heart of the question, because if the question is, did you really fully rationally with your whole heart consent? One, who knows if you did that when you push the green button? Okay, so that just moves the problem one step backwards. But two, it just because you consented doesn't mean that it was a positive experience. And if that's what women are chasing, right? If that's what the left wants to see is women who are satisfied with their casual sexual experiences, that's never going to be satisfied, because I think it's a matter of nature. It's a matter of biology. It's a matter of, if you're religious, it's a matter of theology, right? That kind of question can't ever be answered by Title IX or any other legislation. And that's why I think we're going to sort of endlessly chase these bad feelings until we actually confront the fact that men and women are different. and not just in a superficial way, that are the ways in which we build our lives are radically different. And there are consequences then to the ways we organize society, and what might be considered like good and bad judgment, for example. So until we confront that cultural question, I think we're just going to be talking past each other. I will say the one thing that's really interesting about this era, as opposed to earlier eras of feminism, like the 1970s or like the sexual revolution, is that we all agree that the situation now between men and women sucks, right? Left and right. There are very few people out there arguing that relations between the sexes in 2020 are fantastic and wonderful, and we need to just leave them alone and there's no need for change. I think there is an enormous amount of confusion. So pain on the part of women, and then just utter confusion on the part of men, and fear on the part of men, justified fear, especially with the push-pull between the fact that what works to get women into bed is often more aggressive than the legalistic regime supports, right? So like they seem to have a very mixed messages, right? On the one hand, the feminist class and now Title IX, hopefully not, but potentially returns to this, endorsing this assumption that unless you sign 20 documents with your whole heart, it's not consent. Even if you had 2 drinks, it's not consent, right? But the situation on the ground is always different than that. And if you followed all of those rules to the letter, you wouldn't get laid. So like, that's the thing that nobody wants to say, right? Is that these things won't work for men because women don't like them. But until we're willing to grapple with realities like that and the differences between men and women, we're just going to be having radically different solutions than the left. But I do find it encouraging that nobody is saying that like, this is great, right? So at least it gives us some kind of common ground as to which to argue about the solutions.
Absolutely. Maddie or Zan, final thoughts?
I don't think I could actually put it better than that, but I would just further the point by saying that I really liked watching Sex and the City, and partly because I think it was exploring a sociological premise, which was what would happen if I think Inez actually said it. What would happen if women had sex like men? And it always seemed to me that it was obviously the answer was going to be a disaster. And I think that really we should recognise sex differences, and the appropriate question is what would happen if women had sex like women, and set their own boundaries and all the rest of it. Now, obviously everything we've discussed in terms of sexual harassment and the appropriate legal way to deal with that is separate. And I actually think that the Trump administration's work on this has been very helpful in that regard. It took us back to the 1999 Davis versus Monroe precedent and looked for things that were clearly severe and pervasive and objectively offensive. And I think that's right. We should have that standard. But it just remains to be seen if we'll keep it. So yeah, but I agree that the problem is much broader than the legalistic approach allows for.
Wonderful. All right. Well, we're at 7:30. So I just want to say thank you to all 3 of you for joining us tonight. Again, we're so grateful, and this has just been fantastic discussion, and I learned so much personally. So I hope that we can be together in person. But until then, again, thank you guys so much for joining us tonight. And for everybody who stayed on with us, thanks for joining us. And again, you can reach out to me. I will put my in the chat box if you want to reach out to get a complimentary National Review Online subscription. Thank you, ladies, so much.
And thanks to National Review Institute for hosting this, and to IWF for partnering. This has been a great discussion. So thank you, and thank you all for attending.
Thanks.
Thanks.